In GK part of competitive exams, Indian polity or the Constitution of India is an integral part. And for most of the candidates, this part is a nightmare and they find it too difficult to score in this section. Actually, the problem is that they doesn't know what to study and what are the important points in the examination point of view. So in this series on Indian polity or the Constitution of India, we are providing you only the relevant facts in the examination point of view. Actually, several questions are repeating from this part. So we are 100% sure that if you go through this series, you can definitely achieve a very good score from this part within minimum time. A Constituent Assembly is formed on 1946 December 6, and the first meeting of which happened on December 9, that is 3 days after its formation. The total number of members of the Constituent Assembly was 385, of whom 93 were representatives from the Indian states and 292 from the provinces, that is British India provinces. After the partition of India, the number of members of the Constituent Assembly came to 299. It took 2 years, 11 months and 18 days for the Constituent Assembly to finalize the Constitution. And in the first meeting, 287 members were participated, and out of which 7 were women. The first person who delivered a speech in the Constituent Assembly was Acharya Kripalani, and the temporary president was Sachidananda Sinha. Later, Dr. Rajendra Prasad became the permanent president. And in 1949, November 26, the Constituent Assembly adopted the Constitution, and which is very important. This is the only date, 1949, November 26, which is there in the Constitution or which is mentioned in the Constitution. Only date which is mentioned in Constitution is 1949, November 26. And the provisions relating to citizenship, elections and provisional parliament etc. were implemented with immediate effect, that is from the 26th November 1949 onwards. In some question paper you can see this particular question, that is what are the provisions which are immediately implemented. And in 1950 January 24, all the members of the Constituent Assembly signed on the Constitution. And in 1950 January 26, the Constitution came into effect. Although the skeleton of the Constitution was derived from the Government of India Act of 1935, many provisions were imported from other constitutions of the world. And the most important of them are, first one, Government of India Act of 1935, which formed the basis or blueprint of Indian Constitution. And from the Constitution of South Africa, we adopted the provisions related to the amendment of the Constitution and the procedure of the election for the election of Rajya Sabha members. And from the Constitution of former USSR, we adopted the provisions related to fundamental duties and ideals of justice, which is mentioned in the preamble. And from the Constitution of France, we adopted the principles of liberty, equality and fraternity, and the republic concept which is mentioned in the preamble of the Constitution. And from the Constitution of Germany, we adopted the provisions related to emergency. From Constitution of Ireland, the provisions related to directive principles of state policy. Actually, it is a repeated question in many of the question papers. That is the provision of directive principles of state policy, or DPSP, is taken from Constitution of Ireland, and the provisions related to elected president is also taken from that of Ireland. And the Constitution of Canada, we have taken union list and state list, and also the residuary powers, that is we have union powers and state powers, and the other powers which are not enlisted in union and state list, or union, or the power which is not under the union or state is known as the residuary powers, and it is to the union government. Residuary powers, it is to the union government, and that concept is taken from the Constitution of Canada. And from the Constitution of Australia, concurrent list is taken, the concept or the provisions related to concurrent list. So it is very important to remember these three things, that is the union list and state list. It is from Constitution of Canada, and concurrent list, it is from Constitution of Australia. And other very important thing is that fundamental right and the preamble is taken from the Constitution of USA. These are the very two important parts that we have taken from the Constitution of USA, fundamental rights and preamble. And other thing that we have taken from that is, it's actually not so important, that is the removal of Supreme Court and High Court judges, and the concept of judicial review. Okay, it's so important. And then the functions of president and vice president, it's not so important. The concept of fundamental rights and preamble, it is taken from Constitution of USA. It is very important. And from the Constitution of Great Britain, we have taken the concept of single citizenship and the provisions related to lawmaking procedure and the parliament system and the office of CAG. As you know, the Constitution of India now consists of around 442 articles divided into 22 parts and 12 schedules. And the examination point of view, you don't want to study all these articles. And what are the things, or what are the important parts and schedules and articles that you must remember, or you must have an idea on, as given here. Actually, the first four parts, you should definitely have a clear concept on that. Actually, the part 1, that is article from 1 to 4, consists of union and its territory, and part 2, there is article from 5 to 11, it consists of, or it is related to citizenship, and part 3 on fundamental rights, it is from article 12 to 35, and part 4 from 36 to 51, it is on directive principles of state policy. Actually, now it is very important why we are having so many problems related to this directive principles of state policy. And for A, it's very important. On 51A, it is fundamental duties, and I think you know that we have taken the concept of fundamental duties from the former USSR constitution. And the other most important articles that you want to remember is first one, Article 17. It is related to abolition of untouchability. Why it is important is because of that this is the article passed by raising the slogan Mahatma Gandhi Ki Jai. So it's very important. And Article 352 to 360, it is related to emergency. As you know, we have three kinds of an emergency in our India, and in that first one, 352, it is a national emergency. When we have a war, for example, when we have war with Pakistan or China, we are imposing these 352, article 352 for national emergency, and we have seen 1972 and like that. And 356, it is to impose presidential rules in states in case of failure of constitutional machinery in the state. And article 360, it is financial emergency, and it is very important to remember that we doesn't impose this financial emergency yet. It is the only emergency that doesn't come into act after the adoption of constitution. Article 360, financial emergency. And article 368, it is related to constitutional amendment. At present we have 12 schedules in our constitution, but you don't want to remember that 12, you don't want to remember only these 6. The first one, the first schedule, it is on union and its territory, that is giving an idea regarding the 28 states and 7 union territories with territorial demarcation. And the next important one is the 7th one, which consists of 3 lists. As I already mentioned to you, we have 3 lists: union list, state list, and concurrent list. It is the 7th schedule in which we have enlisted these 3 lists. And it is in the 8th schedule that we have included our 22 languages which are recognized by the constitution. And 10th schedule, why it is important is because of it consists of the anti-defection law. Anyway, we will see it in later. And 11th schedule and 12th schedule are very important because it includes the powers and other things related to panchayat. 11th one it is related to panchayat, and 12th one it is related to municipality. It is the article 368 which empowers the parliament to change or to amend the constitutional provisions. Why there is a need for amendment? Because as we know, as we progress, there is a need to change some parts or some provisions of the constitution. So we have already more than 120 amendments are there in the constitution, but you don't want to remember all those things. You want to remember only these, some 6 or 7. First one you definitely want to remember, it's year also. First one it happened in 1951, and it included the ninth schedule to the constitution, and the seventh constitutional amendment act of 1956. Why it is important is that through this amendment the implementation of the state reorganization act was made possible, and that's how the Andhra Pradesh came to existence on the basis of language. So it's very important. And 42nd Constitutional Amendment Act of 1976, it's also known as mini constitution, very important. The 42nd Amendment made fundamental changes in the constitutional structure, and it incorporated the words socialist, secular, and integrity in the preamble. Again, very important. And fundamental duties were added in Part 4A through this 42nd Amendment Act, which is very important. And 44th Constitutional Amendment Act of 1978. This amendment was brought out by the Janata Party government, and a right to property was taken away from the list of fundamental rights, and it placed in a new article. So this is the amendment through which we taken away the right to property from the fundamental right list. Actually it was we have 7 fundamental rights initially, so through this amendment it changed to 6. So it's very important. And 52nd Amendment Act of 1985, this amendment was brought about during Rajiv Gandhi regime with a view to put an end to political defections. It added 10th schedule to the constitution, and which contains the modes of disqualification in case of defection from the parliament or state legislature. And the 61 Constitutional Amendment Act of 1988, it brought about an amendment to Article 326, it's not important, for the reduction of voting age from 21 to 18 years, which is very important. The amendment which reduced the voting age from 21 to 18 years is 61 Constitutional Amendment Act of 1988. Actually came into exist on 1981, and it's again was during Rajiv Gandhi regime. And the 86th Constitutional Amendment Act, again very important, on 2002, and added a new Article 21A after Article 21, which makes the right of education for children of the age of 6 to 14 years a fundamental right. For enforcement of fundamental rights, the judiciary has been armed with the power to issue the writs. And the power to issue these writs for the enforcement of the fundamental rights is given by the Constitution to the Supreme Court based on Article 32, and to the High Court based on Article 226. That is simply based on Article 32 a Supreme Court, and on Article 226 a High Court can issue writs if there is any violation of fundamental rights. And what are the different types of writs produced by the courts? First one, habeas corpus. Actually the word literally means to have a body, and this writ calls upon the person who has detained another to produce the letter before the court. For example, a person is detained by another person, then the court will order the letter to produce the detained person in front of the court. That is what habeas corpus means. And the second one, mandamus writ. You want to remember this word meaning actually. Habeas corpus means to have a body, then mandamus, it is mandatory. And what it means actually, it literally means a command. It commands the person to whom it is addressed to perform some public legal duty. For example, a public official is not doing his duty, then the court can say that it is mandatory to do that work within this particular time interval. So that's what it means, mandamus writ. And it cannot be granted against the president or the governor of a state for the exercise and performance of the powers and duties of his office. It cannot be done against the president or governor. And the next one, the writ of prohibition, it prohibits. What it prohibits actually, it is a writ issued by the Supreme Court or High Court to an inferior court, and it says that you can't go ahead with that, and we prohibit your duty, or we can say that you doesn't have the legal right to go along with that. The higher court is saying that to the inferior court is that you doesn't have the right to go ahead with that. So it is the prohibition writ by which the higher court prohibits the inferior court's actions. And certiorari, it commands that it is to be certified. So what are the actions that you have taken? It is to be certified. So that is certiorari right. And quo warranto right, actually it is against a person holding a public office, and it seems that he is not suitable to that post, and that is the court will check whether that person is suitable to that person or not. In some question paper you can see a question that out of the following, which one, choose the one which is not a constitutional body or which is a constitutional body. So you want to know what are the constitutional bodies actually. Constitutional body simply means it is a body which is there in the, or which is there in the constitution, or about these bodies there is a mention in the constitution, that's all. Actually these bodies works based on the provisions that is there in the constitution. So first one, election commission, very important, and article 324, you want to remember these things. You want to remember these constitutional bodies and their articles. Election commission, article 324, very important. And the public service commission, both for union and state, it is 315 to 323. You don't want to remember the article, but public service commission is again a constitutional body. Then finance commission and its articles, it's very important, article 280. National commission for SC and ST, article 338 and 338A respectively. Then controller and auditor general, CAG, article 141 to 151, article is not so important. Then attorney general of India, article not at all important, attorney general of India and advocate general of state. Attorney general of the nation, and corresponding to that we have advocate general. These attorney general and advocate general is related to law procedures. And then special officer for linguistic minorities, the article is not at all important. And you want to remember one thing is that the planning commission, it is not at all a constitutional body. In many question paper you can see whether the planning commission is a constitutional body or not. Planning commission, it is not at all a constitutional body, and it is not mentioned in the constitution.